Oh, by the looks of things, it must be legal AF after dark. Donald Trump used Don Hankey and his company to post his bond, or did he? And why is Don Hankey, Mr. Hanky Panky, why is he going on interview after interview throwing Donald Trump inadvertently under the bus, suggesting that he doesn't know where Donald Trump's cash came from or other assets to back the bond, which is a big no-no in the anti-money laundering world and requirements, that he negotiated with Donald Trump about the bond and was willing to post the much larger bond at the time that Donald Trump's lawyers were telling the attorney general that he couldn't get a bond anywhere when he had Don Hankey in his back pocket. And Letitia James, the New York attorney general, has had enough. She's seen the actual bond that's been posted to stop the enforcement of her $465 million judgment, and neither she nor Judge Engoron know what to make of it. It has errors in it. It shows that the company backing the bond does not have the financial wherewithal in order to keep the bond in place. And there's now going to be an evidentiary hearing just called on because Donald Trump can't seem to find anybody who's proper to lend him money or lend him credit. And that's all coming up. We break it down on Legal AF. Take a listen.
But let's get right into it, Michael Popok. And I'll toss it to you early on because I gave a bit of a long intro. The New York Attorney General civil fraud case. Donald Trump was hit with a $464 million judgment there. This is not a criminal case, so do not get confused with the disinformation out there. And I had to remind Don Lemon in one of the collabs that we did as well that in a criminal case, there's a bond that's paid. That's where you see if it's like a really bad guy, like $1 million or $5 million cash bond for them to be out of jail pending the trial. That's not what this is. This is a civil case. There is a civil judgment. Donald Trump has already been determined to have lost the case. For example, in the E. Jean Carroll case, Trump was adjudicated to have sexually assaulted E. Jean Carroll and then defamed her. He's the loser. So if he wants the privilege of appealing after being the loser, what the law says, you have to post a bond equal to the judgment that the winner has so the winner can feel secured during the pendency of appeal, that the money won't be hidden, concealed, or otherwise, removed during the pendency of the appeal process. Same thing here with the district attorney's case. They're the winners. Trump is the loser. $464 million loser plus post-judgment interest. So if Trump wants the privilege now, he has to follow the same rules as all of us, despite his whining and media saying, oh, we've never seen this before. Nope. Every single case, if you want to stay the enforcement of a judgment, you got to post a bond that's equal to the judgment amount so the winner can be secured and the loser can have the privilege of staying the enforcement of the judgment so the winner can't immediately start seizing assets. So Trump was given that benefit of the doubt, which I think you should never give him, by the appellate division. Trump was claiming essentially that he was indigent or didn't have the money, so they reduced the bond from $464 million to $175 million. Then they gave him an extra 10 days. And as I've said before in other shows, you give Trump an inch, he takes your life. You give him an inch, he takes your life. He views you as weak, and he will make you look stupid for giving him any benefit of the doubt ever. It's why you can't do things like that. And boy, is he making the appellate division look stupid because he's now posting a bond that doesn't seem to meet the threshold requirements. Popok, what are we learning that Trump did this week?
Yeah, and I like your description a lot of the bonding process, and just to continue it, and we'll continue these things on our Patreon and our Patreon account and for patrons. Bonds are posted all the time in civil courts. The main place that you and I, as practicing lawyers, deal with bonds is, yes, in the appellate world, where you post the supersedious bond to stop the enforcement of the judgment until you continue to litigate the issues when you're on the losing end of the judgment, as you described. But you and I deal with bonds all the time in the area of injunctions, when you're asking the court to use its equitable powers to stop something or force something to happen in the way of an injunction, either a temporary restraining order or a preliminary injunction, and you're asked to post a bond, and that bond is calculated at the amount if it turns out later in the case that the injunction was improvidently or wrongly granted, the damage to the person that has been enjoined, and the trial court will calculate the amount of that bond, and the bond gets posted. So I've been involved with cases to make the point that the other side gets the injunction, wins the injunction hearing, but doesn't have the money or the wherewithal to post the bond. So it's a Pyrrhic victory. They win, but they can't get the injunction in place because they can't post the bond. And that's okay. That's how I was involved with a case years ago, one of my first cases when I practiced in New York, where the other side won, but we won because they couldn't post the bond. And because they couldn't post the bond, the injunction never attached, and therefore you move on. Now, for those who are sort of new to all of this, not us, or people that want to misstate or mischaracterize, we've never seen such a thing. Happens every day. The party that needs to post the bond, they either post it or they don't. And if they don't get the relief that they're looking for, plain and simple. Donald Trump's got many, many problems here. One I had never envisioned. He actually used a bonding company that's not only a crony of his, owned by a crony of his, and a Trump donor and supporter, but somebody who can't keep his mouth shut. I thought that Donald Trump would be the biggest problem to Donald Trump in the bond arena. Don Hanke, or as you and I like to call Mr. Hanke, Mr. Hanke is the worst bonding owner ever for Donald Trump because he can't keep his mouth shut. He keeps giving interview after interview to ProPublica, to CNN, to CBS, where he says all sorts of things that undermine the bond and Donald Trump. For instance, he told ProPublica that he was actually willing to give the larger bond for $464 million, and they were just down to figuring out which assets, not cash. He was willing to, that's the difference. He was willing to take real estate and other pledges of assets, and that's what they were negotiating. At that very moment that the lawyers for Donald Trump were telling the appellate division, First Department, which is the appeals court, that they've looked everywhere and they can't find a bonding company, including going to 30 different ones. One's not named Knight Specialty Insurance Company owned by Don Hanke, Mr. Hanke. But that's a lie. And you as an officer of the court, you have an obligation to have candor to the tribunal. Don't lie to your appellate bosses or appellate judges. So they should have updated their filing and said, we told you we can't find it anywhere. You need to lower the bond. We got a guy. Mr. Hanke, he's willing to do it. We just haven't gotten around to finalizing it yet. But they didn't. And then the appellate court, relying obviously on the affirmations and the declarations that were false because they had Hanke in their back pocket, no pun intended, they lowered the bond to $175 million. And then Hanke continues his interview and says, and they said, well, thanks, Don. We're not going to use you this time. The 175, we're going to take care of it. And then 3 days later, they came back and said, no, we need you again, and we're going to use cash. Here's another problem. Don Hanke told reporters that he doesn't know where the cash came from Donald Trump to back the bond. We have a word for that in the law. It's called the violation of anti-money laundering laws, Bank Secrecy Act laws, and the Patriot Act. You need to know your customer. That's literally what it's called. You need to know the source of funds. And if you don't, from a bonding company perspective, you may have just violated federal law. So you have that problem. This is the logorrhea of the mouth of Don Hanke, he's just the gift that keeps on giving to the New York Attorney General and ultimately to Judge Engoron, who, as you alluded to in the opening, is going to be holding a hearing on this. Why? Because when they posted the bond, whatever piece of paper, that's all it is. It's a piece of paper supposedly backed by somebody, a company with the wherewithal financially to back the bond dollar for dollar. And it says on its face, we fill in the blank bonding company's name, who are, I don't know, they said they're not authorized to do business in New York, but they said they're authorized to post bonds in New York. And they try to get some magic language right, which they didn't get right in the bond. And they didn't have the right attorney in fact listed, and they didn't have the right power of attorney filed. All sorts of, they might sound like picayune things, but, our entire practice in the law is based on understanding and mastering details in picayune things. And so in there, they also forgot, to file their financials. This is ironic, right? Donald Trump, who never met an audited financial that he didn't try to defraud the auditors with, and rarely use audited financials, hired a company that doesn't have audited financials because they're not a publicly traded company in any event, who submitted non-audited financial statements that are 3 months old to the New York court system and said, see, we have plenty of money. But then when you look at the finances that they finally filed after the first bond got bounced, right? And the clerk gave them more time to refile, and they did refile. They got almost everything right, except that when you look at the finances, this company's underwater. This company doesn't have enough surplus cash, right, to back the bond. They're $158 million surplus, meaning money they have above their debt liabilities, against a $175 million bond. They're short. Now, they may say, well, we're backed by a $2 billion parent company, also owned by Don Henke. But there's no relationship that's established in the filing that shows that Don Henke's parent company gets to step in and make up the difference. So on its paper, this looks like an insolvent company that's been hired by Donald Trump, backed by a guy who makes his money giving no and low credit loans in the auto world. That's his business. And so nobody in the New York bar, like me, was shocked. We would have been shocked the other way if the New York Attorney General didn't call the bond. It's like when you're in a poker game and you say call. I don't think you have those cards. In New York, it's called proving the bond. And you can, on the other side of a bond where you are the person entitled to get the bond in your place, you can say prove the bond, meaning come into a courtroom with all your evidence and all your finances and prove it to a judge that you actually can stand behind that $175 million. I mean, Letitia James is already upset that in her own way, that she doesn't have a fully backed bond dollar for dollar behind the $464 million judgment. She had to take a 175 because that's what the appellate court gave based on misrepresentations by Donald Trump. But at least she wants the 175. And Judge Engoron is very interested too. And I assure you, Ben, at this evidentiary hearing where the bonding company has to come in with its lawyers and its proof and the lawyers for Donald Trump all in front of Engoron, this is going to open up an entire Pandora's box for Donald Trump. It's going to include the statements that were made to the New York Appellate Division about his inability to find the bond based on statements and interviews made by Don Henke, the owner of the company. And this has gotten so, then I'll kick it back to you, Ben. This has gotten so in the weeds and so much more time than Don Henke wanted to spend that he actually, I don't know if you caught this, Ben, he actually said in a recent interview that he had charged Donald Trump a low rate fee for the bond itself. It's usually 1% to 2% of the bond amount. And he suggested that he charged less than that. And now he's saying, if I had known I was going to get caught up in an evidentiary hearing and all of this, I should have charged him more. And it's not helping Don Trump for Don Henke to constantly looking for the spotlight in media interviews. Just as a last contrast here, when Donald Trump posted his bond for $91 million in the E. Jean Carroll case about 3 weeks ago, he went to a legitimate bonding company that's owned by a large insurance company that's also publicly traded, Chubb Insurance, and their division related to bonds. Okay, the Chubb Insurance guy and the Chubb Insurance guy is a very famous insurance executive who's the son of a controversial insurance executive, wrote a one-page letter, sent it out to his investors explaining why he posted the bond. That was the last we ever heard of the guy, because that's normal. You know, Chubb doesn't give interviews about his bonding decision in any way. Not when you go to the king of the subprime mortgages or subprime auto loans. He appears to think he's the celebrity here and gets to go on television. And now Judge Engoron gets to pull it all together with a hearing that you and I will be able to cover in about a week. And if they don't prove up that bond properly, and Judge Engoron is not satisfied that that company has sufficient wherewithal, then the bond drops. They'll have to report that to the Appellate Division First Department, and then Letitia James will ask for special permission to continue to collect on the bond. And I'll kick it back to you for the monitor issue that came up about what Letitia James wants to do with the monitor.
Look, there can be broader issues too about lying to the court. There may be crimes that are being committed here in dealing with the other financial fraud judgment. This could open up a Pandora's box into so much more. Take a look right here about what Don Henke said in this Reuters interview. He said that the cash collateral is being held at a brokerage firm and pledged to Knight, specialty insurance company, and that Knight can access it if needed. Quote, this is what Henke's saying to Reuters. Quote, I don't know if it came from Donald Trump or from Donald Trump and supporters, Henke said of the cash Trump provided for collateral. Now, I'm speculating here, but what if it came from supporters? That goes to your point that you have to know the source. That's why there are these anti-money laundering rules in effect. Is he pledging RNC money? Is he pledging political action committee money and super PAC money? Is he pledging money from from Trump media? What is he pledging here? And the fact that the bonding companies out there saying, I don't know where it came from, and they're being quoted as saying that, that is just unheard of, but it's so Trumpian. And, we're not going to spend time talking about it here because you and I have done a million hot takes on it of the Trump media debacle and it crashing this week. But I'll just mention this point here. The same way Trump has like Alina Habba as his lawyer, the independent auditor for Trump Media, which is supposed to be this publicly traded company, blah, 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 blah. Granted, we've seen the financials, $58 million loss, $4.8 million total revenue. But the independent auditor is like just some dude with a small office in Colorado who, in his independent audit, to this guy's credit, he says that Trump Media has substantial doubt about continuing as a going concern based on its massive loss and may not be able to survive much longer. So you have everything that this person touches has some element like this. And that's why I always go, folks, this isn't a political thing. This isn't like Democrat, Republican. It's just about competence. It's about fraud. It's about deceit. It's about corruption. It's about everything he does. Trump's corrupt to the bone. One point I do want to raise, though, Michael Popok, is I know there are some people who I've seen who are critical that Justice Engoron set this thing for, late April. And then they're saying more delay, more delay. This is what Trump wanted. Look, I agree with you on the fact that this is what Trump wanted. The appellate division is the one that you should be angry at, not Justice Engoron. He has to set it at a normal noticed motion schedule. And so he set it, to allow the parties the opportunity to file their briefs. That's why he set it the soonest day, basically, he could to allow briefing. And to then have an evidentiary hearing so that it's compliant with the law. But he was constrained that the appellate division, when the only fact that had developed since the trial where Trump lost was that the former chief financial officer pled guilty to felony perjury, and that was not in Justice Engoron's order. And then Trump files a motion with the appellate division, which is just like, trust me, bro. And the appellate division is like, okay, I guess we're going to have to reduce it now from 464 to 175. It's almost giving a reward to someone who doesn't just have unclean hands, but whose main witness is now a felon again. It was already a felon, and now a felon who turned the New York court system into a crime scene. So frankly, shame on the appellate division for doing that. But Justice Engoron's going to be strong and tough in his order. And we always know New York Attorney General Letitia James is going to be strong and tough. She sent a letter also to Justice Engoron saying, hey, can you enhance the independent monitorship order that you previously issued a month ago or so in connection with your prior order that the independent monitor would get these additional powers? And one of the things that New York Attorney General Letitia James is asking for in this letter is let's allow, she's demanding that the independent monitor, retired federal judge Barbara Jones, conduct an investigation into whether Donald Trump and the Trump Organization were complicit in the perjury and Trump's lawyers were complicit in the perjury of Alan Weisselberg, the former chief financial officer, since all of those documents that showed that Weisselberg had access to the things that he testified and lied about, and they were in the documents that he knew these things were lies, but they were never turned over in response to the subpoenas and the formal discovery requests. Retired federal judge Barbara Jones do a 2-week investigation right now into that and report back to the court about whether Trump and the Trump organization's complicit. I think that the New York Attorney General's office is teeing this up for another case. And whether that case is a criminal referral or another civil case or seeking more damages, I think, that's what's going to be happening there. And then they said in this letter to allow the independent monitor to kind of be a little bit more nimble other than these quarterly reports. If the independent monitor sees things that are suspicious, to be allowed to report it right away to the New York Attorney General on an ex parte basis, as opposed to just submissions of kind of quarterly reports, because a lot of this stuff needs to be monitored in real time. I don't think that's a controversial ask. And in light of the conduct and the fact that a felony was committed in his courtroom, I don't think Justice Engoron's going to deny that. I think Justice Engoron will accept that. One thing I'm interested in knowing, though, is if I was the New York Attorney General's office, as it relates to this issue of the bond, I would request also in a letter to Justice Engoron that Engoron order in that same 2-week period, because, right, Popok, it's right before that April 22nd hearing date, allow Barbara Jones to conduct interviews with Hanke and all of those people. Let the independent monitor do an investigation for 2 weeks as well, so that in addition to just the briefing, by the time you have that hearing, you could potentially have had depositions taken with retired federal judge Barbara Jones going to Trump and all these people and writing a report. I wonder if that'll happen. That's what I would do if I was in the New York Attorney General's office. But that's my own view.
I know. I agree with you. Look, you have a monitor. You have the unique device that's in place because of Judge Engoron. It has been in place for 17 months almost. Now with new robust superpowers, sounds like we're doing an ad for a new product at the supermarket. But the new and improved monitor has tremendous amount of powers. And why wouldn't the judge, who's properly referred to Barbara Jones as an officer of the court and a direct, who's directly responsive to Judge Engoron, he's got an insider in there that he can trust like no other in the Trump organization. And Engoron, to your point, has to be concerned when the lineup of all of Mr. Hanke's interviews and all the things that he has said, where you and I have just slapped our forehead and said, "What? What do you mean you don't know where the cash came from? What do you mean you don't know if it came from donors or not? What do you mean you don't know if it came from the company or not?" And you've got a company, and all of it, it's not just a company who's under the monitorship. It's all of the assets, including Donald Trump's main source of income and funds, which is his trust. And how has he funded this account that's backed it up? If he had been able, as you said, this is an error of Trumpian proportion, right? It only happens in his world because a person who hasn't committed fraud as adjudged by a New York judge, who hasn't had his auditors and accountants fire the client for fraud because they believe they've been defrauded, who doesn't have their chief financial officer go to jail and can be convicted twice of both perjury and tax evasion. That kind of person can get a bond on their IOU because they're trusted and trustworthy. You don't have to go to, there used to be an ad when I was a kid, Earl Shine, $99, paint your car for $99. I mean, this is, I know Don Hanke's an $8 billionaire, but he runs this thing like a family office where he even said, I took a look at it. I don't know what he actually sounds like. I took a look at it and I said, he's got enough liquidity from what I see. I'm going to give him that loan. That was the underwriting. That was the entirety. And I said this before I even heard Don Hanke speak in his interviews, that he obviously went Donald Trump to somebody who's just a family office where one guy makes a decision, and he just decided, and now we know more about Don Henke, Trump supporter, Trump donor, and all of that, who just because he's friends with Donald Trump, he backed $175 million bond, or did he? But I like the way you've outlined what the evidentiary hearing is going to look like. And I think there is a tremendous role for the monitor, who's the only trusted person independent in that room. I love Letitia James, but she's not independent. She's the prosecutor, if you will, of the case. She's the attorney general of the case. But there is a unassailable, ethically bastion of ethics in that room who could be trusted about financial matters, and that's Barbara Jones. And I agree with you. I think she takes the stand where there's affidavits. I think he grants the ability for the attorney general to speak directly to Barbara Jones outside the presence of the lawyers. As an officer of the court, it happens. I've been involved with cases where that happens. And I think he grants that. And you and I will have a lot to talk about. And I also agree with your point. Don't blame Judge Engoron. The appellate division, although they could change if they feel like they've been had by Donald Trump, they could change it, but they're the ones that kick the oral argument on this case out to the September term. They're the ones that decided that the briefing would happen through June and July, and that the actual oral argument about the appeal wouldn't happen until after everybody got back from summer vacation. That's not on Judge Engoron. So the fact that he's, moving around some chairs here well before the deadline for the appeal, who cares? I mean, he's doing it, as you said, properly and allowing there to be proper due process. So there's no challenge by Donald Trump that he didn't have enough time to make out his evidence. But it's going to be a clown show that you and I are going to revel in covering when Don Henke and his people come into that courtroom married in a shotgun marriage to Donald Trump and his lawyers. I mean, if I would pay to do hot takes, don't ever repeat that for those, because it will be must watch TV, must see TV.
You will pay me to do hot takes? I like this.
Wait, does that stay in the pod?
I think you've been stigmatized, and we hear your perspective there. So one interesting thing about the dates and times of all of this is Donald Trump will be in the Manhattan District Attorney criminal case starting the week of April 15th. So when that hearing takes place before Justice Engoron, there's going to be a little bit of shuffling from Justice Merchan's courtroom in the criminal case to the civil fraud courtroom in Justice Engoron. So Merchan to Engoron, we will be covering all of that.
All right. We on Legal AF sit at the intersection of law and politics so that you don't have to. We cultivate and curate the top 5 stories and developments at the intersection of law and politics. We bring them to you every week right there on Legal AF on our podcast. Join us on Wednesdays and Saturdays at 8 p.m. Eastern Time. Find out why we call it Legal AF. And if you already know about Legal AF, there's a clip in case you missed our last episode. Send it off to friends and family and those in your life and say, hey, that podcast that I like so much, Legal AF, here's an example of it, and maybe they'll join our audience. So until my next Legal AF, until my next hot take, this is Michael Popok reporting. Heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know, and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.